Hi, everyone. Thank you for joining us today on this Zoom webinar. We're excited to be able to present this education webinar during this time of self-isolation and physical distancing. As everyone's situation is unique, this information provided is for educational purposes only and not specific advice for your current situation. Should you have any specific questions regarding your situation, please contact your support worker for further discussion. Once we get started, we will do our best to answer general questions at the end of the presentation. For any questions that you may have during the presentation, please add them to the Q&A box, which you will find at the bottom of your screen. If you scroll your mouse around, you'll see some icons appear, and there will be a Q&A icon. And if you click on that, it'll appear on your screen, and this is where you can enter your questions. Should you have any comments or concerns during the presentation, you could also add those comments in the chat box, and we will keep an eye on those as well and help you as best as we can. So today we have the pleasure of having two guest speakers with us, Dr. Ron Posno and Laura Geddes, who will be presenting on the topic, Be Prepared, Not Scared. Dr. Ron Posno is an Alzheimer Society client and a dementia advocate. Ron's focus is with care partners, dementia-friendly communities, and MAID. Ron was a test pilot, school superintendent, skier, scuba diver, wanderer. Take your pick. Ron has done them all. He is most proud of teaching children with special needs and winning a national award for innovation. He is passionate, provocative, and profound. He has lectured and taught in universities and colleges across Canada and the United States. Laura Geddes is a lawyer in the estates group at Siskinds law firm. Laura's practice focuses on estate planning and administration, including the presentation of wills, powers of attorneys, and trusts. Laura routinely advises clients on the scope of their duties as estate trustees, guardians, and powers of attorney. She has a particular interest in disability planning, including Henson Trusts and Ontario disability support issues. Laura is an affiliate member of the Society of Trust and Estate Practitioners. Once the presentation is completed, we will open the discussion for Q&A. I now turn things over to Ron and Laura.
Okay, thanks, Dana. And thank you for the introduction. I didn't know we had to practice superintendent. I've been called stuperintendent, but I thought this would be a new one. Anyway, I'd like you to take a look at this title, Be Prepared, Not Scared. That's not mine. I just love it. I heard it about 3 years ago from another person here at our Alzheimer's here in London. Her name's down at the bottom there, Louise Milligan. Louise had prepared a presentation about this, Be Prepared, Not Scared, because she was the care provider, care partner for her husband. And at the point that she was delivering this particular presentation, her husband was into the 3rd stage and in a special care facility. So she had lived the last part of her life, his life, going through all the stages that I'll be sharing you with. But I love this. To me, I had just been assessed with dementia. I was beginning to find out things and learn things. And like a lot of people, I was scared. I was worried about what might come or not. I'm not now because I got ready. Bruce, can we go to the next part? I took her presentation, Be Prepared, Not Scared, and I broke it into 3 parts. Get real, get ready, and get a plan. And that's what we're going to go through is those 3 parts right now. I hope I want to leave enough time for Laura because Laura is very special to this. It's just fine to get a plan, but Laura's going to tell us how to make it legal and bring us all back to home base as to what we're all about. So let's go to the next slide, please. Now, getting real. means you got to deal with reality. I don't know how to advise people how to do this other than the fact that I know that fear is based on ignorance or prejudice. Fear is as much, or another aspect of fear is denial. And I watch. Now, let me just give you a real example. Sue Oster and I were a few months ago going around London to the libraries talking about dementia, a dementia-friendly community. And at one of them, we had a woman talk to us about her problem. She was, I guess, maybe in her 40s or 50s. Her dad was the problem. Her dad was a retired high school principal from some town up here in Northern Ontario who would not go for an assessment. Absolutely terrified. And I'm talking about a well-educated person, somebody who should know what the heck to deal with in terms of life, but he wouldn't go. I remember watching Teresa sit there in front of us, trying to explain about her dad's fear and why we were going there. So this is as much about people like Teresa, people trying to help their mom and dad and so on. Let me go to the next slide, please. Now, here's what the reality is. I got my picture up there. You can see that. I think that's me. I'm the only one around here with an eye patch. So there's me. Then I go get an assessment. And I'm exactly the same after the assessment as I was before. Teresa's dad didn't need to worry about going to get an assessment. What he's going to do is find out some truth, what some of the reality is. And a large part of what this presentation is about is understanding that, yes, you can get an assessment. You're the same as you were before, but you've got some limits on your life. And I don't know anybody over 70 or 75 years of age who hasn't dealt with the reality that their life is shorter now than it was before they turned 70. We have a declining number of years in which to work. Bruce, let's go to the next slide.
So I'll just jump in there, Ron, before you move on.
Sure.
Just to Ron's point about being the same the day before your assessment as the day after, a really important thing to note about that is that getting that assessment doesn't necessarily mean that you are no longer capable of doing your advanced care planning or that you can't make a will or powers of attorney anymore. So the capacity that we talk about in law to make those documents and to make a decision is really based on a person's ability to understand the factors that are relevant to making that document or making that decision and appreciating the reasonably foreseeable consequences of doing that or not. So for the planning of your will and powers of attorney, a lawyer is going to ask questions about your circumstances to determine whether they believe that you have the capacity still to make those documents and to instruct them. For personal care, so for the power of attorney that deals with healthcare decision-making, the capacity required is a very low threshold. It's the lowest one, only really having an understanding that the person that you might name may need to act for you and has a genuine concern for your welfare. That's all that's required. And that they may need to make decisions for you in the future. For property and a will, the capacity required is a bit higher. It requires an understanding of what you own, where your assets are, their approximate value, and the risks of giving someone the ability to make those types of financial decisions for you, and an understanding that like the people that might expect to benefit from your estate plan and your will. So it's certainly possible to have received an assessment that indicates a dementia diagnosis and still have the ability to do these documents. So I do see a lot of clients in my practice who are in the early or even in the middle stages of dementia and are still perfectly able to give me instructions depending on what it is they want to do. One real life example from my practice, I had a client who had been assessed in the early stages of dementia. He had a bit more of a complicated estate plan because he had children from a previous marriage. He had a girlfriend who was pretty keen on them getting married. And he had an understanding that that could really impact on his estate plan. He came in to see me. He wanted to talk about what those impacts might be. He wanted to make it clear that his intention was to leave the bulk of his estate to his children. And he wanted me to know that if he happened to get married in the future, that perhaps that was not a decision that had been made by him freely. So he was certainly perfectly able to come and give me those instructions, and he wanted to do it at a time when he was still, and he knew he was still able to do that. So we'll talk about this in a bit more depth later, but it's very easy to put these kinds of decisions off. There will come a point for everyone when they are no longer able to give instructions for all of those documents. So it's a really good idea to deal with it as soon as you can. Like Ron said, get the fear out. Don't be afraid to go in and speak with a lawyer about what your options are, and to discuss the will and the power of attorney, which are part of a full plan that we will go over. Thanks, Ron.
Laura.
Thanks for letting me jump in.
Yes, it's all right. You can do it again.
All right, I will.
I can get sidetracked on my own thoughts. Anyway, we're going to go do an anime, not right now, Bruce, but I want to talk about the progression of dementia. This is primarily for people who are listening to this presentation. You have to talk to other people. You may even know some family members or a neighbor or somebody who's afraid to go and get an assessment. And everything that Laura's talking about. Yes, now Bruce, can you make this guy act for me? I call him Benji. He's my brain. Oh, no, gotta go back, Bruce. Wrong slide. Can you make him go up? There he goes. Now, it's going to take 75 years for this little guy to go from the beginning, and now he's at the top, 75 years old or thereabouts, and he's coming down. Takes 10 to 15 years to get to the bottom. Now, at the top, we'd like you to get assessed. Now, the thing is, as you're going up, you must understand that going up starts even before you're born. You're starting to learn even before you're born. In the first month, your brain and your brainstem is beginning to form inside, and that's when you're starting to learn. Now, from that point to maybe 75 years, you're learning everything. Everything that you, I've got to point out too, that your brain is the most important part in your body. Your heart doesn't count, guys. Your heart is nothing but a pump. All your feelings, all your sentiments, all your sensations, all your thoughts, all your learnings, everything about you is in your brain. So you go up, I'm just using 75 years as a thing, you get to the top and you begin to have some concerns. Well, that's natural. You begin to have some concerns about your memory, you have concerns about this or that. Things just aren't as good as they always were. But that's natural, that's normal. And you've got normal aging and you're going to decline, and it's going to take some years to decline. The difference between a person with dementia and a normal aging person is that the decline goes much straighter down. It goes through 3 stages. Now, Bruce, let's go over to the next slide. Yeah. At the top, you're going to go down. At the top, 75 years old, you were independent, you're capable, you're functioning, but it's going to take 5 to 15 years for that dementia to effectively destroy your mind. Everything that you've learned is going to disappear. When you get down to the bottom, when we say complete dependency, your mind, you are nothing more than you were as an infant when you started 75 at the beginning of the 75 years. Let's go to the next slide, Bruce. Now we tend to generally describe this decline in 3 stages. It's important for our planning to understand a little bit about these stages, so I'm going to describe them briefly. And then at the beginning, just like normal aging, the things that you forget, they're nuisances. You can handle that. It's no problem. When we get to the moderate stage, 5 to 8 years down the road, well, these nuisances now become problems for you. These are things that occur every day and all the time, and they're difficult to get rid of. And the last stage, that's when your mind is being reduced to that as an infant, the severe stage or advanced stage or the final stage. I don't care what you call it. But at that stage in your life, you are totally dependent upon somebody else. The thing is, you have moved down so far that you have lost any sense of independence. You can't make judgments. But you can, to go back to Laura's point, at the beginning, at the top, in the mild period, those 5 to 8 years after you were assessed, you're still responsible. You can still make judgments. You can make decisions, and you can take responsibility for it. When you get into the moderate stage, it becomes questionable. Here, they might start talking about taking your license away because you can't drive a car anymore. That's part of this reality. Let's go to the next slide, Bruce. All right. I say get ready. This is it. You've dealt with the reality part. You've lived your life. You got to be 75 years of age. You've got now 5 to 8, 10 years to make a decision, some plans. What you're going to start with, what are you going to need? Now, what you need in the early stages is a whole lot different than what you're going to need at the moderate stage or at the severe stage. So what you're going to have to do to work this out to get ready is you're going to have to figure out what are your needs. And your needs are really some kind of balance between what do you want to do, what you can afford to do, what you're available to do, and what's not on this chart, what you are able to do. Bruce, let's go to the next one. Here's your planning outline. I did mine on a spreadsheet. And I put down my stages across the top. I got my early, my middle, my last stage. And then I got 8 major categories here of things that I had to consider and when they might occur. Let's just talk about residential choices for a minute. Of course, everything comes down to money. In the early stage, you might still be living in your original home, or you might be living in a second home, you might be in a condo. But are you going to be able to handle that when you get into the middle stage? Certainly by the time you get to the last stage where you are completely dependent, you can't likely live in the home that you started out with. You know, and these are difficult decisions. I meet people all the time. They've lived in their home. They raised their family in their home. They've been there 40 years. And now they've got to do something. It's fine if you got the money and you can afford it. Do you have your bedroom on the first floor or the second floor? If you're up on the second floor, are you going to put it in an elevator or a slide thing on the thing? How are you going to get between the main floor and the top floor? Now we're getting into residential modifications. All kinds of issues come into place. You got stairs to deal with, the steepness of those stairs. You've got to understand that by the time you're halfway through the middle stage, that moderate stage, certainly by the time in your last stage, you can't really walk carefully anymore. You haven't got the capability of being up there. You need to go and have grab bars around. You're going to have to put them in your bathroom. You're going to have to put them down the hall. You might even need a special bed to sleep in. Other kinds of modifications you might want to consider. Stairs, but doorways. One of the things to understand is that most of the doorways, certainly the ones going into your bedroom or the closets or the bathroom, can't accommodate a wheelchair. So if you've got to the point where you're being set up in a wheelchair for your life, you're going to have to either change the doorways or you're going to have to change where you live. And all these things have costs. So this is why I'm saying your planning outline, getting ready, is finding out what it is that you want to do. Then you can then work it out to what you need to do. And what are the costs? I had my assessment of dementia I started working on my plan. Louise gave me a good start. She said, go get ready, be prepared. And I started learning about my dementia, what my needs might be. And then I started checking around the community. Where might I live? How could I live? How could I be accommodated? Similarly, so let's go to transportation. We're not going to give you all the details. You have to get this out. You have to find it out. Transportation costs. In the early stage, no problem. If you've been driving around an automobile, you can likely still handle that. One of the considerations you might want to do in today's age is how long you're going to continue with a standard car or one that's equipped with artificial intelligence. Can a person with dementia drive a car with artificial intelligence? By the time they get into the middle stage, I doubt it. Because you see, in the middle stage, where your dependency is increasing, your forgetfulness is increasing. You've also are losing a sense of space or where you are and what you're about. Your judgment slows down. Most people lose the right to drive, have a license, when they get into their middle stages. That's a fact. You can't drive a car anymore. I'm still driving a car, but I'm watching myself very carefully. There are training programs you can get to train yourself as to but I'm very much aware, and certainly my wife, my care partner, is very much aware of what my limitations will be. I hope to be able to turn my license in before somebody says, you better do it. So what do? And I'll just throw in this kind of a factor. You take away the car. Well, in my case, my wife can still drive a car. But what happens when she doesn't want to drive a car anymore? Well, one of the things I learned a couple of years ago from the Canadian Automobile Association, that is, it costs a little over $13,000 a year to own and operate a 3-year-old car. $13,000 a year. Now, if you got rid of that car, you don't need to spend $13,000. And here in London, we have access to taxi companies. Taxi companies will be glad to set up a monthly contract so that I can phone, Sandy, my wife can phone. We can get picked up anytime, anywhere, and we pay once a month. Once a month. You don't have to be bothered with the issue of doing it all the time. They keep track of it. They send you the bill. And you pay it once a month. Well, that $13,000 of operating a regular car can help a lot with the taxi. Food costs. Well, let me tell you guys, in my home, I'm the cook. Sandy has been taking my home cooking for years, and she much prefers that. But now we're dealing with the fact that with my dementia, my ability to cook has tremendously diminished. So we're now looking at other alternatives. We can buy meals already prepared in many of the grocery stores that we're in. Remark here in London provides excellent kind of things. You can also get meals delivered to you. There's several meal plans where they will do all that for you. So that's a factor to put into your plan. How about your food and where's it going to come from, where you're going to prepare it, who prepares it, how they're going to do it. And I'll also throw out and say, here's something that it's not just me. This happens to dementia people. My sense of taste is disappearing. I really can't tell what I eat by taste anymore. I got to be able to see it. And with my sense of taste disappearing, what I want to eat is changing. So the food that we've eaten for more than 60 years, now I'm not so sure I want to eat it. So that's a factor too you throw into your plan. We're at personal needs. Yeah, you're going to have drug plans. You're going to have medical needs. How about some of these orthopedic devices that you might need? As I said, you might need a wheelchair. You might need canes. You might need crutches. You might need hearing aids. Holy cow. It's not unique just to people with dementia that need a hearing aid. You have to have what are you going to do for your fitness program? One of the best things for people with dementia to do is to exercise, regular daily physical exercise. How are you going to do that? in the early stages, in the middle stages? What are you going to do for safety? One of the issues about dementia, it starts showing up particularly in the middle stage and with men more than women, but people wander and they get lost. We've all heard the cases about some Uncle George or Uncle Dan who got lost. Martha's out there, we don't know where she's at. Well, there are safety devices that you can buy and equip yourself with that will keep track of where you are and will communicate back to a common source. Anyway, communication costs, same thing. What are you going to do for recreation? So these are all, as I say, factors to consider, and when are you going to make your changes, what's it going to cost, and plug it here into the plan. Now, Laura, we're just about done. I hope you're ready. Are you?
I'm all set. Yep.
Okay, let's go to the next page, Bruce. Now, I said, get your plan, all those readiness factors. I pointed out, you got to organize it all. You consolidate them all together. You can do it on a spreadsheet. That's how I did it. But here we go, guys. We got to make it legal. And if you didn't start before, now is the time to start it. When have you had your talk? I call it the talk, your talk with your family. Did you bring them into the planning stage? Did you bring them into all those planning? Did you have discussions with them over the dinner table as to where you might live at different stages? What these kind of cost factors are? Did you include them in terms of your wishes and what their wishes might be? Laura, well, I'm sure she can tell you all kinds of stories where the wishes of the family differ from my wishes as a dementia patient. And you don't want to leave it until the last stage to get that sorted out. So if you haven't had the talk with your family, now is the time to do it when you get down to the point where you create your will. Yeah, Laura, it's all yours. I might interrupt because I'm very concerned about care plans and substitute decision makers. So you go right ahead.
Feel free, Ron. Thanks. So really, to talk about it from a legal perspective, when you go to see a lawyer, the documents that they will create for you, there's really three. There's your will, which, to take it back to basics, is just your estate plan. So it sets out what happens on your death, where you want everything to be distributed to, and who you want to administer your estate for you. Your lawyer will also help you with the creation of your powers of attorney. So those are the documents that name who you want to make decisions on your behalf during your lifetime if you become incapable of making those decisions for yourself. There's two separate documents for that. There's the power of attorney for property, so that covers off any assets that you have, real estate, finances, investments, personal property, anything you own. The person that you name in there can make any decision that you could have made while you were capable for you with respect to your property, other than make a will for you or make changes to your will. So you're the only person who can ever do that. And then there's the power of attorney for personal care, which most people think of as being related to healthcare decision making. So it is consent to treatment, it's refusal of treatment, it's directing a care provider as to when to put a do not resuscitate order on a file or to withdraw treatment, that sort of thing. But it's much broader, so it also includes decisions about where you should live, the types of foods you should eat, safety matters, hygiene issues, everything that Ron was talking about in that plan. And then those two documents, the people who are named in that, those are your substitute decision makers. It doesn't have to be the same person for each power of attorney. So you could have somebody dealing with your property, somebody dealing with your personal care. You can have more than one person acting at the same time. You can require them to act jointly in that role, or you can allow them to act independently of one another. Well, they should still be keeping everyone informed as to what's going on. And then the care plan, that is something that most lawyers are not going to walk through with you. They're interested in getting the legal documents in place. The care plan is something you can do prior to getting your estate documents in order. You can do it continuously after those documents have happened. There's really no wrong time to start doing that and to start looking at that. I get a lot of questions about what a living will is. So a living will, there's no legal document that's called a living will. Lawyers typically don't create living wills for you because there's no formal validity requirements for them. So there's no requirements about signing and witnesses and that sort of thing. The living will really is your care plan that sets out your wishes about all of the things that Ron just talked about. And the reason it's really important to do that care plan, to continuously be thinking about it, updating it, having those conversations with the people that you name, is because your powers of attorney do have an obligation to make decisions that are consistent with what they knew your wishes to be while you were capable, to the extent that they're able to carry those wishes out. So the more guideposts they're given, the easier it is for them to carry out your wishes, rather than having to try and think about what you may have chosen to do. Without that expression of a wish, they're thinking about what is in your best interests, what your values were, that sort of thing, and trying to make a decision that is aligned with what they think you may have done. So the more nitty-gritty you can give them, the easier it is for them to carry out your wishes when you're no longer able to do that for yourself. So just going into a little bit about the types of planning considerations when you're thinking about making these documents, particularly the powers of attorney. They're so important to have, because if you reach a point where you're no longer capable of making those documents, you're no longer capable of making your own decisions, there's a bit of a void there as to who can act for you. So certainly with property, there's nobody who can just kind of jump in and make those decisions. Most financial institutions are going to want to see somebody who has the legal authority to do that. For personal care, there is a list of people who can consent or refuse treatment on your behalf in the Healthcare Consent Act. So that's typically a spouse, a child, that sort of thing. It goes through that hierarchy of people, but it doesn't touch on that broader decision making, where you might need to have decisions made for you about entering long-term care facility, you know, safety, general safety, home matters, that kind of thing. So if you don't have those documents and you need someone to make decisions for you, somebody needs to apply to the court to be appointed. At that point in time, they have to make disclosure to the public guardian and trustee of all of your assets. That all goes into court, and the court will decide whether the person applying is an appropriate guardian or not. It's a much lengthier process. It's much more expensive. Your powers of attorney are probably going to run a few $100s as part of a bigger. With the will, it might be, you know, somewhere between $500 and $1,000, depending on your lawyer. The guardianship application is going to be upwards of $5,000. So you can cut down on costs and on difficulty for family members just by having these documents in place.
Laura, could I
Yeah,
butt in just for a moment here?
absolutely, Ron.
Right into a key part, a major concern that many of us with dementia are having to deal with. And quite frankly, many of us older people who don't have dementia have to deal with. COVID-19 has introduced another factor. And I'll put it this way. About a month ago, or a little bit more, Andre Picard, who writes for the Globe and Mail, he writes on health issues on a weekly basis, usually. And he pointed out that we're getting into this COVID-19 stuff, and they were talking about taking all the people who were in care in the hospitals, moving them out, and sticking them into a long-term care facility, because they wanted to clear the rooms in the hospital for all the people that might come in with COVID-19. Now, we've heard a lot about long-term care in the past few weeks. I'm not going to say a whole lot. I have a whole lot. I do know a whole lot about it. When I did my research, I went around to all the different kind of care facilities we have here in this community, and I learned that there are some that I would have no problem living with at all, knowing that they could look after me in terms of all the personal and humane needs that I might have. And there are others that you wouldn't get me into at all, ever. So here we are now. This Doug Ford says we got to fix this, and people are saying we got to have inquiries and commissions and all kinds of. And I like Picard. He just said it simple. We don't need a commission. We don't need an inquiry to tell us what to do. We have known, as I knew, and I'm not the expert, We have known for some time what has to be fixed in these long-term care facilities. Now, put it this way. You're in or coming up to this final stage. Your family really can't accommodate you in their own home. It's very difficult trying to look after somebody in their own home. So they want to consider a nursing home, you want to call that, but it's really a long-term care facility they need. What are they going to do? You've got it spelled out, hopefully, you've got it spelled out in a long-term care plan, in your advanced care plan. You've got that all spelled out, hopefully. But things change. Andre pointed out with this COVID-19, maybe to get into a hospital today, we should expect at the hospital admission a presenting of a long-term care plan. Maybe we should have the presenting of a DNR. For those who don't know what I'm talking about, DNR means do not resuscitate order. For those of us who worked out a care plan, we know what a do not resuscitate order is. This directs the emergency people, this directs the emergency room, this directs the other people. No, you don't want to be resuscitated. Now, you decide this while you're cogent and capable, and you work it out with your doctor, and you sign it. It's a legal document. Your substitute decision maker should know about that. And they should be prepared to present that at the desk, admission desk of a long-term care facility, at the admission desk of a hospital. I cannot say strongly enough of the need to have those people who want to consider medical assistance in dying a request form. That should be done while you are capable of making that decision, making that request. And you should have those documents along with a DNR as part of your care plan to be able to present to the people who need to know what it is that's best for you.
Yes, absolutely, Ron. And having those documents prepared and the person that you have appointed aware of what you have done and what your wishes are really sets you up for a situation where your wishes are going to be respected. So you talked about going into long-term care. I've had clients who set out, here are the top 5 long-term care facilities that I would be willing to go in if it came to that, right? And so they have sort of done what you've done. They've given consideration to that, and they've given that instruction to their substitute decision maker, so that it's easy for them when the time comes to know which places they may be interested in going in. So having that kind of open communication is really important, particularly for the substitute decision maker, but also for the rest of the family. So if somebody has 3 children, if they don't tend to get along well, they've appointed 1 or more of them as their substitute decision maker. Everyone in that family, to the extent that they're able to communicate, sometimes they have some difficulty with that, should know what that person's wishes are, so that there's no infighting about, mom's going into the hospital team is asking, do we want a do not resuscitate order placed on her file or not? The family is all aware of what mom has decided, what she's discussed with her doctor, and that she's already completed that form. It just sets her up for success in having her wishes respected.
Well, Laura, I'm quite prepared. I'd love to be able to answer some questions that people might have, or they might want your opinion on some matter. Can we turn this over to Dina to get into the Q&A part? Oh, we got this slide.
We just have 1 slide left. So This is us beating our advanced care planning drum about just communication, making sure that, I have clients who come in and they don't want to tell the people that they've appointed in their documents that they've appointed them. And I can't recommend strongly enough that the people that you've appointed should know that they have been appointed. They don't have to come in and sign anything at the time the document is made. They don't need any record of their consent. But at the time that the document needs to be used, if that's when they're finding out, they may decide that they're not up to that challenge. It is a lot to put on someone to make those decisions on behalf of another person, and they can renounce before doing anything, and then you're left with a bit of a void if you don't have an alternate person. So frequent and open communication. If you're not able or don't feel comfortable communicating with your full family about it, I've had lots of clients set out in a letter what their wishes are. They keep that in the file with their wills and powers of attorney, and it gets released at the time that the power of attorney needs to be used.
Communicate, communicate, communicate. I don't know how much more strongly, Laura, you and I can talk about this.
Yeah.
Now, family, absolutely. Your lawyer, absolutely. Your doctor, absolutely. Everything that you've thought about in your care plan should be there. Now, your friends are another issue. There are a lot of people who are very secretive and don't want to share that with your friends. That's a personal decision. In my decision, I've got friends. Sandy and I, my wife and I, we don't have children. Our power of attorney for health and for property are nephews and nieces. We borrowed from my brother and sister-in-law as to who can back us up. They know, those families that they come from know, and we live, fortunately, we've got some good friends where we live, and they have a general idea of what it is that we need or want. Because it could very well be that without our family immediately handy next door, somebody has to say something when the ambulance shows up and can point to where the folder containing the care document is on top of the fridge so that people can deal with that. So communicate, communicate. You can't say it strong enough. Now I think we can go to the last slide, can't we?
I think so. Yeah, I think we're ready.
Yeah. I'm just going to point out to this poem. I can't think of a better poem for people with dementia or people looking after people with dementia. That to me says what it's all about. And to me, that's what this whole get real, get ready, get a plan is about. We want to be able to do that. I had a mentor in my life give this to me some 40 years ago when I assumed a position of responsibility with the Board of Education. And he shared that with me. And it's meant a lot to me since. Anyway, we're going to leave this slide up. You can see how to reach Laura. There's her thing. There's my thing. I got a website up there. My website, don't try to communicate with me through my website. That won't work very well. But it's got all kinds of information about what I've done with respect to supporting people with dementia and people who are interested in medical assistance in dying. So if you want more information, go to my website or contact me directly. And Laura, you've got the same kind of thing, can't you?
Absolutely. Yeah, people can reach out to me at my email there.
Okay, Dina, are we ready for some questions?
Yes, we are. So thank you for the great presentation. So I'm going to start off with, we actually have a comment here and a question. So this is the author of the Hot Chocolate and Decadent Cake Society, Alzheimer's, and the Choice for Maid. She has listened to Ron's presentation before, and his manner of presenting and the information he provides is extremely well done. Also, the information presented by Laura Geddes. In being prepared, what also needs to be addressed is the reality that those with dementia who currently may meet the criteria for MAID and have made their decision to have MAID before their window of giving informed consent has narrowed. Does your Alzheimer chapter support this choice, or are you still neutral with a wait and see what unfolds approach? Not recognizing this choice and not offering support programs for those who would like information and support needed to make this choice is in essence marginalizing those with dementia who need your support.
Well, Ms. Breeze has put her finger right on a major issue. Medical assistance in dying is a law that was passed here in Canada in June 2016, 4 years ago. It came out in such a way that anybody who was facing the possibility of death and a period of agony, of pain, enduring pain, long time pain, could request the assistance of a doctor in dying. Now that was available for everybody except people with dementia accept people with mental health problems, accept minors under age of 18. It was such that the Alzheimer Society of Canada was not in favor of MAID when it first came out. Last fall, they changed their policy. They're in favor, or excuse me, I don't want to push it too strongly. They are neutral now. If you want MAID, go ahead and ask for it. If you don't want MAID, don't ask for it. But we still have to get the law changed. And when this law came out 4 years ago, there was immediate, within months, 3 court challenges of the law. One in court challenge in Vancouver, one here in Toronto, one in Quebec, challenging the law because it didn't deal with what they believed the Supreme Court of Canada had permitted. The Quebec case has been decided for people in Quebec, and then it was referred to the federal government, the justice people, to change the law. To change the law particularly for this matter of what we call advance requests. This would enable a person with dementia so that when they are in the mild and in the early parts of the moderate stage, when they're still cogent and capable, that they could request it. They don't want it now, they want it at a subsequent time. So that's what the Supreme Court of Quebec, Superior Court of Quebec ruled, and that's what it's gone to the federal government. The federal government was given 6 months to make the changes, and we're running out of time because the pandemic can't interfere. They introduced a bill called C7, which accommodated most of this, what we call an advance request, which will allow people with dementia to get in. Now, I also point out that for the people on Vancouver Island particularly, and for some people in BC, they have a much more liberal interpretation of the law than we have here in Ontario or other places. So it's still going to be a provincial responsibility, but it's going to be controlled by federal law. And until we get the federal law, which hasn't been passed yet, still up and open, people with dementia legally in other provinces other than BC cannot really access medical assistance in dying.
Okay, so our next question is, should your caregiver present the original DNR if you are admitted to hospital or a long-term care facility when you are admitted?
Laura, why don't you take a whack at that?
Yeah, I can speak to that. So I think that really depends on the care team there. They may just want a new DNR signed. It may be possible to get the original from the doctor. They might specify exactly what it is they need to see. But certainly if they have the original DNR, they can present that at the time that the admission is taking place. That question most typically will be asked at the time that there's an admission to the hospital, and certainly at the time that there's an admission to a long-term care facility. And now most long-term care facilities also want a copy of the powers of attorney, so they want to have those on their file so that they know who to contact to get further direction in the event that it's needed.
I'd like just to add to that, Laura. I generally recommend this when I'm talking to people. I have prepared a DNR. I also have a request for medical assistance in dying, but I particularly have my advanced care plan. All this material that I've reviewed with the substitute decision maker, all that's in a plastic envelope on top of my refrigerator, along with the contact names and contact information for my substitute decision maker. So that if something happens and the ambulance shows up here in the middle of the night, my wife has it handy to show them, or our friend down the hall, because we live in an apartment building, knows that it's up there and can present it to the ambulance people. So they get the information immediately. But they also particularly have the information of the contact people so that they can deal with the immediate problem and then get in touch with my substitute decision maker who happens to live in Toronto. So
Yeah, and it's really wonderful to have that in a central location that everyone kind of knows where that is, the people that are in your home, as well as the people who are going to be making decisions on your behalf. And I'll just speak really briefly about the ambulance attendees, the EMTs, when they come. They have an obligation to resuscitate someone no matter what. So even if the person who is named in your power of attorney document is standing there saying, I personally know that this person does not want to be resuscitated, they will still do that unless you have a confirmation of DNR present. So this is a document that confirms that on file with your family doctor, there is a DNR. And that is the only form that can be handed to the EMTs when they arrive that will allow them to not go through that resuscitation process. So I've heard of people having that like in a very central location on their fridge. Some people have stuck it, if they live in an apartment, as you do, Ron, they put it on their front door so that if the substitute decision maker can't be reached, it's very clear that that document has been prepared and is there, because otherwise the EMTs do have an obligation to resuscitate the person.
Okay, thank you. So the next question is actually in our chat box, and this is specifically for adult children. Are there any tips on how to broach this topic with parents, especially where dementia is present and parents are not getting things into place?
That person asked a key question. It's one of the major problems we face in this world of dementia. There are parents who don't want to deal with this at all. In fact, I'll even back off. There are people who don't want to deal with this whole aspect of dying. They don't want to talk about it. And even if a child brings it up, they defer it. They push it off. I don't have any magic things here other than trying to bring to them information or stories of real people who ran into real problems because they didn't work it out. Laura, you can tell stories because with the experiences that you've had here, but again, Canadian Association of Retired People reported 2 years ago that 57% of the people over age 50 don't have a will. Now, even if I didn't have dementia, I would consider that to be irresponsible. For people to be that age, that old, and not dealing with the reality that they're going to die, it just boggles my mind. This whole thing, what I'm hoping to point out is you've got to deal with the fact that and what you're going to do with your care plan is spell out how you want to die. We're not talking about the actual death itself. We're talking about what you're going to do to live up to it. But if you don't put anything there, your kids love you. They don't know what to do. They're desperate. And there are very strict limitations as to how much they can do without any kind of power of attorney or will. Laura, you can provide all kinds of stories, I'm sure.
Yeah, I mean, I see it a lot. And unfortunately, this is a common problem where the older generation doesn't want to deal with it and the kids are left kind of scrambling, trying to figure out what to do. The thing that I think appeals most to people is typically the financial aspect to it, the expense of going through that guardianship application, because at some point someone is going to need to be appointed to make decisions, and appealing to the idea that what the children want to do is respect what their parents want and to know what that is, sometimes kind of carries weight. But what I found most drives people into my office who have been resistant to doing this kind of planning is seeing a close friend go through something where they did not have the correct planning done, and they see how difficult that is, or even the difficulty that someone has in managing an estate after that person has passed away if they don't have a will and everything is a bit of a mess. So unfortunately, usually it's firsthand experiences, seeing friends and family go through that drive people to finally get their planning done. But I would say for those adult children, just yeah, appealing to the financial aspect of it. Look, getting this done and in place is going to save you a lot of money down the road, because eventually somebody's going to need to be appointed, most likely, and that's going to cost you like $8,000 probably. And that, you know, it's helpful to the children so that they are not in the difficult situation of trying to piece everything together after the fact.
Thank you. So I just want to make a special note that we just have a few minutes left, so we're going to try to answer a couple more questions in this time. We also have a comment in the chat box that says, thank you, Ron and Laura. It was excellent.
Thanks.
The next question is, can Laura speak to capacity assessments? What needs to be done to determine if someone still has the capacity to legally document their own POA? Who normally determines capacity?
Yeah, this is a great question. So there are people who are qualified capacity assessors. So these are healthcare professionals who have had additional training that qualifies them to perform a capacity assessment on a person. Typically, the person they're assessing needs to consent to the assessment. So if consent can't be obtained, we've seen situations where family will have to go and get a court order to have that person assessed. It doesn't happen very often. Those people can assess whether that person is capable of giving instructions on making a power of attorney, either for property or personal care or both, or of making their own personal care or property decisions to kind of activate the power of attorney that's always already in place. So you see that happen. Sometimes the capacity assessment is done. There's a clear indication that that person is no longer capable, and then the powers of attorney are used. More frequently, we kind of see a situation where the parents are, because typically it's parents or the adult generation, is sort of recognizing that they need more assistance, and the person that they've named is kind of gradually stepping in to help them take over, and the family is kind of recognizing this gradual change. But to have it legally determined, there is a list of qualified capacity assessors. I have that list available. If anybody wants it, just email me. I'll set it out to you. I think it's also available on the Ministry of Health and Long-Term Care's website.
Thank you, Laura.
Thanks.
So the next question and comment, this was an excellent presentation. Thank you very much. When preparing a POA, do you recommend a POA with one decision maker or joint decision makers? I have a sibling and she is not very involved with my parents' care. She's just not capable of doing more. This presents many challenges because 99% of corporations and organizations, including banks, CRA, utility companies, etc., follow whatever they have on file. So this creates a lot of practical bottlenecks in managing the care for my parents. A joint approval is often not readily available or practical. What options do siblings have? Is there a practical solution so everyone will feel that their decisions and legal interests are protected?
Yeah, so whether to name someone jointly or have one decision maker depends on the person's situation. I often see a lot of people who want to have all of their kids on there. They don't want somebody to feel left out. Then they have a choice as to whether to name them jointly or jointly and severally. So jointly is exactly what you've set out. All of those organizations are going to require a signature from both people. Jointly and severally allows either one of those people to go and make that decision and sign off on that document. They can act without the signature of the other person. Typically, I would recommend to my clients that if they're going to name a bunch of people, they either name them like jointly with a majority rules clause or jointly and severally, unless there's like somebody who they're worried about going rogue and who needs to be reined in, which in that case probably should not be, that person should not be on that power of attorney. But we do see situations where, you know, they feel that they need to name all of those people. And that's what they end up doing. And those ones typically run into problems. But the practical solution really, you know, if you're jointly on there and you can't get the signatures and your sister hasn't done much to deal with the parents' assets, she could sign a renunciation if she felt comfortable doing that. If your parents were capable, they could create a new document sort of setting out that you were named jointly and severally so that either one of you can act. And the person who's still acting still does have that obligation to consult with other supportive friends and family members. So the other people in the family who are not on the power of attorney, who are still supportive of the grantor of that document, should still be in the loop about what's going on and have the ability to kind of have their say, with the person who's actually named having the final decision-making ability at the end of the day.
I'll just add a little bit, personal and observable. I have lived most of my life on what I call the KISS principle. And I can't think of anything worse than trying to have a committee decision about an ailing parent with a group of family members. Just practically impossible. In my case, trying to keep it simple, my wife and I, we have a decision authority, finance and health for each one of us, but one of us may not be able to do it. That's why we have these backup people, my niece and my nephew. Now they're signed jointly and severally so that if one can only be reached, they can make the decision. Now, we've all talked about it. We sat down over lunch 25 years ago and started working all this out. We've met several times since. They know exactly what it is that we want from care. They know all that kind of stuff, and they trust the other person to make the decision if they can't be reached. It's a matter of trying to do it simply and directly. And I say, I can't, Laura, I'm sure you've seen all the issues of trying to have a committee decision about whether mom should have a resuscitator or not. God, that's impossible.
Yeah, it's really difficult. And the more people that you have on there, just the more possibility it opens up for disagreements that can't get resolved without litigation. So that's something we really want to avoid if we can.
Thank you. So we have just one last comment before we wrap things up. It was an excellent discussion, very helpful. So at this time, I just would like to say thank you to both Ron and Laura for taking the time out of your busy day to present this valuable presentation to us. We are very thankful, and we know that your information will help many people. I also wanted to just reference, Ron mentioned earlier in his presentation about the risk of people going missing and considering the thought of using technology for planning. We actually have an upcoming webinar that is scheduled on Friday, June the 19th. It's Living Well with Dementia and Harnessing Technology as a Tool. And you can register on the website for this upcoming webinar. And we have 2 guest speakers who will also be presenting on this topic and also talking about the research that backs this up. I would also like to thank everyone for attending this webinar. And when you leave this webinar, you will be asked to complete a short evaluation, and we would appreciate it if you could just take a few minutes just to fill this out so it can help us for future planning. Thank you again to everyone for joining us today, and we hope that you enjoy the rest of your day and stay well. Thank you.